everyone, and welcome to this video tutorial on how to apply the law on gross negligence manslaughter to a criminal scenario. In this tutorial, we're going to be looking at the Zoe and the landlord mini scenario. We're going to remind ourselves of what the law on gross negligence manslaughter is before looking at how we would use the idea structure to write a really nice answer to this question. So let's start by looking at the situation we've been given. Zoe tells her landlord, Gary, that she can smell gas coming from the gas fire in her flat. Gary ignores her complaints because he doesn't want to pay the bill. Zoe speaks to a doctor about her headaches and he said it was probably gas poisoning. Zoe tells Gary about this and Gary still does nothing. Zoe dies of carbon monoxide poisoning. And you're being asked to discuss whether Gary is liable for gross negligence manslaughter. Now, this is a nice question because you're being told specifically what crime to advise Gary on. Remember, in the exam, you might just get a vague question that says something like, advise Gary on his criminal liability. If you're not being told what crime it is, you would have to apply anything that's relevant, whereas here we know we only have to do GNM. But if we have a little scan of this situation, we can see that what's happened is Gary's been told that this gas fire looks like it's leaking gas. He's done nothing, even though a doctor has said that it's probably leaking gas. And Zoe's died. So if you got just a vague advice question, you've got death. So it could actually be murder. Because Zoe's died, so it's an unlawful killing for reasonable person in being under the Queen's peace. Remember that for murder it can be an unlawful act or an omission. So here Gary's done an omission because he's ignored her. So although he's ignored her, that could still be murder. In terms of the mens rea for murder, he certainly doesn't have intention to kill, direct intention to kill, but he could have oblique intention to kill. Because if someone tells you that they can smell gas coming from a gas meter and the doctor says that there seems to be gas poisoning, then, and you still do nothing, death or serious injury is a virtual certainty, and you must have realised that. So that could potentially be murder. But the much more likely situation is gross negligence manslaughter, and for us, that's what we're being told to advise on anyway. I just want to really stress to you that our homicide offences do overlap, and so if you do get a scenario like this and you're thinking, oh, it could be murder or it could be that doesn't mean you're wrong. A lot of the time it could be one or the other. But here, the much more likely outcome is that we would want to be prosecuting for GNM, not murder. So let's remind ourselves of what the law on GNM is. We'll just go to our summary page here. This is going to be a very quick recap. Remember that there is a separate video tutorial which just goes through all of the law on GNM and all of the cases. So it might be worth going back and watching that again quickly before you come to try and apply the law on this. Gross negligence manslaughter is our second type of involuntary manslaughter. Remember, UAM is the other. And involuntary manslaughter is where there has been a homicide, a killing, but our defendant doesn't have the mens rea for murder. They don't have intention to kill or do GBH. And our elements for GNM come from the case of Adamaker, which was about that incompetent anaesthetist, if you remember. And this case outlines the three requirements that you need to prove to find a defendant guilty of gross negligence manslaughter. Firstly, the defendant must owe the victim a duty of care. Secondly, they must breach that duty causing death. And thirdly, the negligence is so gross, it's considered criminal. And this is where GNM, gross negligence manslaughter, comes in. From that third stage. So we looked at a number of cases on owing a duty of care. Now, just a reminder that gross negligence manslaughter, negligence is usually a civil case. It's not usually criminal. But what we're saying here is that the negligence is so bad, it actually deserves to be a crime against the state and conduct deserving of punishment with the criminal law. But actually, our main case where we get information about owing a duty of care is actually a civil case, and you can tell that from the name Donahue and Stevenson. And Donahue and Stevenson, really famous negligence case, which we look at in year 2, gave us the neighbour principle, that you owe a duty to those persons that you can reasonably foresee are likely to be affected by your acts and omissions. And that's called the neighbour principle. And it's quite vague, this idea that if they're close to you, you owe them a duty. So over the years, we've had lots of cases that we can look at that help to give us duty situations. So Singh, very useful for us today, tells us that landlords owe a duty to their tenants. Lichfield, a master of a ship, owes a duty to his crew. Stone and Dobinson, telling us that you owe a duty to anyone you voluntarily assume to look after. Wacker, really sad case involving the immigrants in a lorry. This is saying that even if the victims are involved in some sort of illegal activity themselves, you still owe them a duty of care. And Evans was an interesting drugs case that we actually looked at in UAM, if you remember. And this gave us the interesting principle that if you create a dangerous situation, i.e. giving someone drugs and watching them OD, and then you fail to summon medical help, then you owe them a duty through creating that situation. When we're looking at whether this duty has been breached, all the usual rules of causation apply. So we use the but-for test, de minimis, thin skull, novus actus interveniens. We've got to be sure there's no break in the chain. And then finally, we've got to determine that the negligence is so bad, it can be deemed gross negligence. And the test for that comes from the case of Bateman. Now that that's more fresh in our minds, let's go back to the Zoe situation. And as we would in the exam, we'll highlight the key issues as they arise. So Zoe's told her landlord that she can smell gas coming from the gas fire in her flat. So I'm going to highlight that because that's telling us she can smell the gas, which is dangerous. It's a flat. He's her landlord, so I'm going to highlight that as well. Gary ignores her complaints. So I'm going to highlight ignores because that's telling me he's done an omission here. He has failed to act. Zoe then speaks to a doctor, said it was probably gas poisoning. Zoe tells Gary about this and Gary still does nothing. So I'm going to highlight that because that's making it even worse. He ignored her, an omission, and another omission even after a doctor has said that there's seemingly gas poisoning, and then Zoe dies. And we know it's carbon monoxide poisoning, so we know that her death is due to the poisoning. So let's remind ourselves of the idea structure and look at specifically how it applies to GNM. So as always, we use idea, we identify, define, explain, and apply. So you're going to identify who your defendant and victim is. So we would be saying here, Gary may be liable for gross negligence manslaughter for the death of Zoe. Or D, we define the 3 elements of GNM from Adamaco: duty of care, breach causing death, and the negligence was gross. And then for our E, or explain, you are going to explain each of those 3 requirements with all of the cases. So it's just a list in your D, all your cases come in your E. And your E is then a checklist for your application when you're applying it to the defendant's case. So you've got to look at it and think, did they owe a duty of care? And we know that Gary's a landlord, and the case of Singh tells us that landlords owe a duty to their tenant, so we've got that element met. Did he breach the duty? Yes, it's clearly a duty of landlords to maintain gas fires, and the issue of causation here. If we go back to our scenario, it's clear that he meets but for, he's more than a slight or trifling link to the death, there's no novus actus interveniens. Be careful, sometimes students see the word doctor and go, oh, if there's a doctor, it might be the doctor's broken the chain. But if you look here, the doctor hasn't said or done anything wrong. So there's no novus actus interveniens here. So that means we can prove causation. And the final element is, was his breach in not doing anything about that fire gross using the Bateman test? And if we look at what he's done, I would say it's grossly negligent. Maybe if he just ignored her first complaint, that wouldn't be bad enough. But the fact that he ignores her twice after a doctor has said it's gas poisoning, to me, that is showing a disregard for health and life, and it's conduct deserving of punishment, as in Bateman. On my next slide then, I've just done you a very rough bullet point answer to this. So you might want to pause the video here so you can have a closer read of it. Remember, the ones you can ignore, they're just a rough mark scheme for in class. So you can see I've identified, I've defined, I've explained. Let me just point out, mine are just bullet points. You would obviously explain with full sentences about all of these cases. And when you get to breach, you need to outline all of the rules of causation. Okay, so say that for causation, we need to prove factual, White and Paget, using but for, legal, de minimis, Kimsey, thin skull, Blau, novus actus interveniens, could be broken by, third party, list your cases, etc. So I haven't, just so I can fit it on a slide, but you must go through it all. Talk about the Bateman test for gross, and then the bit that we're interested in today, the application. So as we've said, he owed her a duty as her landlord. He's breached it not having it serviced, and you could talk there as well about the fact that he's ignored her twice, which is clearly a breach of his duty to her. And then I'm talking about causation. Again, mine's very brief. I would want you to go into quite a lot of detail here. So I would say that not checking the gas fire has caused Zoe's death because but for is met, and you'd say Zoe wouldn't have died but for him failing to maintain the gas fire. He's more than minimal cause using Kimsey. Seeing the doctor won't have broken the chain, as we've said, the doctor didn't do anything that was palpably wrong. And then I've said here, in terms of gross, it's likely that Gary's negligence is gross because it's obvious that smelling gas poses a real danger to life. Everyone would know that's a massively dangerous thing. So to use an actual quote from Bateman, he's shown a disregard for life. And you can say that it's so bad, it's conduct deserving of punishment. And then always nice to give a conclusion. So in conclusion, Gary's guilty of gross negligence manslaughter, can get a discretionary life sentence. Okay, so I hope that was helpful for you in seeing how to apply the law on GNM. So you could have a go at doing this yourself, either on the Zoe mini scenario or on a different scenario from your booklet.